and also she's now working as associate director of the New India Center here. So that's exciting.
Yeah, I'm just like a sponge right now, taking all of this in because it's a whole new arena for me, and I'm loving it. So
Thank you.
I'm excited for the talk.
Hi, welcome, Francesca. Hello, Esteban. So, Francesca and Jack, should we start or should we wait a couple of minutes? I don't know what your experience has been with the other panels.
I think we can get going, and then people will hop in at different times.
Okay.
Hello, everyone. How are you?
Hello.
Sorry for the delay, but it's raining a lot in Medellin, and when it rains, the internet for some reason is super slow. So here I am, and I can see you perfectly.
No, we're just on time. We always say like a dean is always late, so.
But no, today I came home exactly because I didn't want to be disturbed today. I wanted to report the talk and no meetings.
Okay, so let me just since the small group, but I'll still introduce myself and our co-panelists. So I teach at Seattle U Law School and write in the fields of international human rights, comparative law, and I study of judicial institutions. So I'll talk a little bit about my work as I provide background on the paper that I'm presenting, but for now, let me introduce my co-panelists. So prior to coming to Seattle, I was at Cornell for 15 years. And in that time, I met these two wonderful people, one of whom was a student of mine and now is the dean of IAFIT Law School in Colombia. And the other was David, who's a fellow and now runs the clinical program in the Catholica Pontificia University in Quito. So that's it. Esteban, you both have JSDs from Cornell and LLMs, and Esteban has worked in the Colombian Constitutional Court. David works on indigenous rights issues, and that's a very brief introduction. Perfect. So what I thought I would do is that I could focus on my paper about comparative perspectives on India, on term limits debates in the United States based on the Indian case study, and then Esteban and David will talk about Colombia and Ecuador respectively, and then if there are questions, we can take that. So the topic, and maybe I'll set the stage a little bit as well as to why this sort of topic is relevant and important today in the United States. And I'll turn my email off. So as you know, maybe you know, or you don't know, well, so the genesis of this. So I started to work on the Indian Supreme Court almost 5 years ago, but from a quantitative empirical perspective, working with co-authors at the University of Chicago Law School, as well as National Law School in Bangalore. And we coded like 5,000 published decisions of the Indian Supreme Court from 2014 to 2019. There were a lot of papers that came out of that, and this is sort of a comparative side project. This is how I developed my ideas, by learning more about the Indian institutional design, the functioning, the problems of the court. And, and being part of the debate here in the United States on term limits, I thought that it's useful to draw these comparative perspectives into the conversation. As or you don't know, in the United States, calls for reform for the US Supreme Court were heightened after Trump replaced Justice Ginsburg with a conservative judge, Amy Coney Barrett, at the tail end of his presidency. And this last minute appointment stung even more deep in light of the fact that the Senate Republicans had prevented President Obama from appointing Justice Scalia's successor during the end of his term. So in April, Biden created a commission of 36 law professors and one practitioner to study this issue. Incidentally, only 5 of them don't teach at like the top 10 schools, and 2 have resigned now. And they're all constitutional law scholars. Given the composition of this commission, some suggested that, you know, they weren't really going to propose any change or reach any decisions. They've held 4 hearings, and their initial report released last week seems to prove that true. They were charged with 3 main topics, one considering the size of the US Supreme Court, whether it should be increased, whether term limits should be imposed from life tenure, and reviewing the case selection process. From the discussion materials they released, they seem to not propose any changes to the 2 issues of size of court and case selection, but they do seem to be in favor of term limits. And term limits have gained consensus in the US from both the conservative side and the liberal side. So when they did cite, they did have a couple of comparativists testify before the commission. One of whom was Tom Ginsburg, and you know, they did, when they looked at the comparative materials, however, they did a very formalistic analysis, sort of a comparative law by the numbers, right? And they cited, well, most countries in the world have term limits on their courts or have mandatory retirement ages, and that was sort of the limit of their comparative analysis. And so I hope that this conversation brings in a more in-depth, robust case studies and sort of the real laboratories for how, in practice, have countries and courts dealt with term limits or mandatory retirement age. So I will argue that we gained 3 insights from looking at the Indian Supreme Court. And just to be clear, the Indian Supreme Court doesn't have term limits, but it has a mandatory retirement age of 65, which effectively acts as a term limit because judges are appointed at older ages increasingly, and yet they have to retire at 65. So the 3 lessons I think we can learn is, first, when judges are not appointed for life tenure, they're likely to seek post-retirement employment, and it could potentially lead to pandering for employers. And some empirical studies have shown that to be true in India. And anecdotally, that's also seen to be true. So the second consequence of not having life tenure and having greater turnover in the court is potential doctrinal instability. We witnessed this in the Indian Supreme Court, but to be clear, there are other institutional design features besides just the short tenure of the court that lead to this, which I'll talk about. And the final point is more of a warning less of a warning of the potential negative consequences, but more of a distinguishing feature of the Indian judicial systems. So one of the arguments proponents of term limits in the US make is that the process will be depoliticized if presidents have the ability to appoint judges more frequently. And that in India, it actually is completely depoliticized, but that's not because of the fact that there's constant turnover on the court, but it's because judges appoint each other, and it's not part of the parliament and doesn't even get involved in the process. So just a very quick snapshot of the Indian Supreme Court. The size of the court today is 34 judges. At independence, the court had 8 judges, but Parliament has expanded the size largely to enable them to deal with the increasing workload. I know in the United States there's a debate of whether whether one needs a statute or a constitutional amendment to increase the size of the court. In India, that's pretty settled. The Constitution says that it can be decided by the Parliament. So the Indian Supreme Court hears significant more cases than the US court. It grants full hearings to about 10,000 cases per year, gets 68,000 petitions, and issues about 1,000 opinions per year. The Chief Justice of India has significant power in ways that the Chief Justice here doesn't. In India, someone becomes a Chief Justice if he or she, it's always been a he, is the senior most judge. And their tenure now is about 12 months. So there's also constant turnover. They're also the master of the roster. This means they can decide which judges determine the constitutional law cases and important cases. And as I mentioned, it's the Chief Justice of India, along with his 4 senior-most colleagues, that nominate judges to the Supreme Court. And the executive essentially rubber stamps them. These people are known as the collegium. In 2015, the court even quashed an effort of reform by the parliament to appoint a judicial commission rather than allow these judges to self-appoint. But they said that that law itself was unconstitutional. So as I mentioned, judges must retire at age 65. And in our study, what that's meant is that since judges are self-appointing, there's no reason for them to want to appoint younger judges the way the political system here wants to do. So judges are being appointed at older ages. They're required to be judges for longer. They're required to work harder. Which effectively means in the last 10 years, the average judge spends 5 years on the Indian Supreme Court. So now moving in a little bit more detail into the problematic features that I talked about. So the mandatory retirement age of 65 means that the judges are relatively young. That means that they want to work, and they do work past their retirement. But what's interesting about India or different about India is that their future employer, their largest future employer is the government. And you might ask, well, why? About 70% of judges took up post-retirement jobs in this one study, and 36 were appointed by the government. And that's mainly because, or one important reason is that the government provides these lavish estates in Delhi for all their officials, and no one can afford these estates or these aren't even available. The only other person I know is one of the richest men in India that lives in this area. So continuing on that employment, they lose this employment as soon as they're no longer justices. And if they continue on some kind of tribunal or a human rights commission, then they also can get back these privileges. So, incidentally, there's been sort of discussion of how, and the government is the largest litigator before the court. So one empirical study based on a data set of cases of the Supreme Court of India between 1999 and 2014 suggests that judicial independence may be compromised because of this early retirement and the work for the government. So the study by Professors Anay, Dam, and Co. of the National Law School in Singapore compared the behavior of judges who retired close to an election against the behavior of judges who retired when an election was farther away. And the study found that judges are more likely to issue pro-government decisions when there is not likely to be government turnover immediately after retirement. In other words, their data demonstrates that judges are more likely to issue pro-government decisions when they think that the government won't turn over, right? So that there's some incentives to pander to the government who might potentially give them a post-retirement employment. It also had other findings, which I won't discuss in more detail, but and then the second lesson we learned from the Indian Supreme Court is about doctrinal instability. So doctrinal instability manifests itself in two ways. First, 90% of the court's work is done in two-judge benches, right? They never sit in bank. You might wonder, how did 34 people ever decide one thing together? Sometimes they sit in 5 or 6 panels when there's a constitutional decision. But these two-judge benches often are deciding run-of-the-mill cases and deciding it very differently than each other. And there's a significant conflict. But even in these more important constitutional cases where judges sit in larger panels, the Indian Supreme Court is known to change its stance on issues. One example that is pretty well known comes from the issue of declaring Section 377 of the Indian Constitution unconstitutional, which is the one that criminalizes sodomy. First, a smaller bench said, overturned the Delhi High Court ruling and then found that it was constitutional, 377, but then a higher bench declared it unconstitutional. And in that time period, the CJIs had changed, the Chief Justices of India had changed, and they had the power to appoint who they wanted to. So then what are these risks of institutional design and functioning that we can, what can we learn for the US case example? right? I mean, India is, this Indian Supreme Court has 1 billion people under its jurisdiction, which is a significant portion of humanity. It's the world's largest democracy, the world's largest court, if you base it on the population under its jurisdiction. And what we can learn is that the question is then there a risk for United States judges who are term limited to also pander to future employers? The proposal that is currently gaining currency in the US is the one proposed by Calabresi and Lindgren. Even though the first term limit proposal was proposed in the mid 1980s in the legal scholarship literature, the one now that we're all talking about is one that would impose 18-year term limits, and it would be staggered. So a judge would retire every 2 years, and a president would be able to appoint a new judge for 2 judges for every term that he or she is in power. And this proposal, people who've, Calabresi and Lindgren, who've put forward this proposal, have assumed that presidents here now will be less motivated to appoint younger judges than they are now, because they're spend a finite amount of time in court, in the bench. But I disagree with that. I think that even under a term limited system, presidents are still incentivized to nominate judges who are young, because if they do die while they are in office and a president from a different party is in power at the time, then that other president would be able to appoint the judge for the remaining period of time. So there is still some risk that you would lose this particular judge. And if these judges continue to be appointed at young ages, then they will, when they retire, seek post-employment work. The US House bill and Calabresi try to account for that and say, well, they can go sit, they can have a judge's salary for life, and they can go sit on a US Court of Appeals. But would they want to sit on a Court of Appeals after they've been on the Supreme Court? And particularly the experience they have on the court, the contacts they will make, will be very lucrative to private employers. Now, the Indian Constitution specifically prohibits judges from going back to private practice, but none of the proposals in the US have that prohibition. And so there, again, might very well be, some pandering, some risk of judges trying to pander to future employers. So the other potential possibility is doctrinal instability, right? As I mentioned, under this 18-year system, judges will leave every 2 years. On the other hand, in the last 17 judges to leave the United States Supreme Court had spent an average of 27 years on the court, right? So it's significantly shorter. The term limit would change the dynamic quite a bit. And this could open the question of whether there's a revolving door. This revolving door could open the question of whether they're going to flip-flop on major issues of significance. So one other empirical study that I cite to by Professors Sunbai and Sherry measured this fluctuation. What would happen if there was hypothetical term limits, right, of a court from 1973 to 2019? They found that if there were 18-year term limits rather than life tenure, then it was likely that there would be significant flip-flop, particularly or on Roe v. Wade, and that's what they studied. They said that what would happen if there were a term-limited court is that Supreme Court would change its collective mind on abortion 3 times in 46 years, and also produce extreme swings with on other reversal issues. So doctrinal instability is obviously problematic for a lot of reasons. In India, it's actually created this escalating number of petitions. Lawyers file cases when they don't have when the outcomes are not guided by precedent, but guided by the personalities of the judges. And so they take a risk and just file a petition. And this could also happen at this court, the Supreme Court. We might see an increased caseload because we no longer know what the composition, how the judges might rule based on changing composition. And also, obviously, it impacts lower courts, and it creates challenges of giving them guidance. So the final point before I conclude is about the depoliticization of the process. As I mentioned, a cursory look at India might say, well, look, it's not politicized. We never hear about judicial appointments. And that's because the Supreme Court of India, as I mentioned, 5 people with very little transparency. They basically just meet secretively. Sometimes they've now been trying to issue meetings. People have been requesting minutes of their meetings. They meet in secret and they nominate judges. And this is also problematic because it's very nepotistic. It's very gendered, and there's a lot of sexism in this process. But regardless, it's not politicized because the executive rubber stamps it. So in conclusion, the United States stands apart. It's true that we stand apart from the rest of the world in appointing judges for life. My research suggests that at least 99 countries in the world have term limits in their high courts, and 87 require judges to retire at a certain age. But I think an in-depth look at the world's courts and to see the actual functioning of the courts as real-life laboratories is important to add more information and more context for us to consider here in the United States. And that's the hope of this panel. And I look forward to hearing from David or Esteban, whichever one of you want to talk about the experiences of the courts in your country. Would you like to?
Should I go?
Sure, go ahead.
Okay. Thank you so much, Sheetal, for those, for that wonderful paper. I was reading and I learned a lot from India, and more importantly, like how important is this discussion, and like to bring the experiences from different parts of the world, particularly the global south, that usually we don't look like to try to deal with these kind of issues. What I didn't write a paper for this conference, so I'm just gonna make like some remarks. But I'm very inspired by some of your work, Sheetal, and I wish I could write one for the next conference, because you forced me to think about our own experience with these kind of discussions. So maybe what I'm gonna do very briefly is to talk a little bit about our structure of how courts in Colombia work, because we don't only have one constitutional court, but we have 2 other important courts, and I think that brings also information valuable for the discussion. So in the first part, I will talk a little bit about that structure of the courts in Colombia, and in the second part, I will refer to some history, but I will be very briefly to some historical discussions about these issues in Colombia. This thing about term limits is something, or no term limits for judges is something that we haven't discussed that much in recent years, but it's a discussion that has been present in our constitutional history. And in the last part, I will refer to some more contemporary discussions that we have had in Colombia that deal exactly with some of the things that you raised in your paper. So I will go back like for more contemporary discussion on conversation. For instance, the age of the justices, because the age of Colombian constitutional, usually Colombian constitutional justices are very young. Some of them have arrived to the court at the age of 40, for instance. So if they only remain in the court for 8 years, so they leave the court when they are 48, and that presents like some challenges to the legal profession and to the judiciary in general. So first part, like our system of courts. So in Colombia, we have 3 high judicial courts: the Supreme Court of Justice, the Consejo de Estado or Council of State, and the Constitutional Court. The Supreme Court of Justice, la Corte Suprema de Justicia, deals with labor law issues, civil law, criminal law, commercial, and agrarian matters. The Council of State, or el Consejo de Estado, deals with administrative law issues, legality of acts, state contracts, state liability issues, tax matters, electoral matters, among others. And the Constitutional Court, which is like our more renowned court, like the well-known court worldwide, the Colombian Constitutional Court, deals essentially, of course, with constitutional matters, but those are tutela actions, which is the action in Colombia that allows people to defend and protect fundamental rights, or challenges that any citizen can present before the court of the laws enacted by Congress. So it's like the traditional judicial review of legislation. So we have those three courts: Supreme Court, Consejo de Estado, Council of State, and the Constitutional Court. In all of those three courts, the justices of these highest courts are elected for personal terms of 8 years, and there is no possibility of re-election for those justices. Those are repeated personal terms of 8 years. The difference between the way the Supreme Court and the Council of State justices are elected is that they elect themselves, just as Indian Supreme Court justices. The justices elect themselves, like their justices. And the only thing that is particular in that process is that there is another high court, which is called Consejo Superior de la Judicatura, like a high council of the judiciary, which is like the administrative chamber of the justice, which deals with the administration of the judiciary. This particular institution, which is considered another court, has been, it has been subject of a lot of criticism in the past, because people say that it's very political, like the work that they, of this Consejo Superior de la Judicatura, or High Judiciary Committee, which is in charge of elaborating the list of people, of names, of lawyers that are going to be elected by the Council of State or the Supreme Court of Justice. The justices of the Constitutional Court are not elected by themselves. They are elected by the Colombian Senate. So you will think, this is a very politicized process, because it's the Senate of Colombia, the one that chooses the justices of the Constitutional Court. But the interesting thing is how those justices of the Colombian Constitutional Court are selected, because they are selected by list of 3 people, ternas is what we call, that send the Supreme Court, the Consejo de Estado, the Council of State, and the President of the Republic. So the Colombian Constitutional Court has 9 justices, and 3 of them are elected by decision of the President, of the Supreme Court, and the Council of State. They send 3 names, a list of 3 names, and the Senate has to choose one of those 3 names. So in general, if you think, 6 out of 9 justices of the Colombian Constitutional Court came also from the judiciary, because the names are sent to the Senate by the Supreme Court and the Council of State. And only 3 names are sent by the President of the Republic, the Colombian President. So this is basically like the structure. So in brief, Supreme Court of Justice, Council of State, Constitutional Court, Supreme Court of Justice, and Council of State, they elect themselves. They all have a personal term of 8 years. And the Constitutional Court, the justices are elected by the Senate, by the Colombian Senate, and the names are sent to the Colombian Senate by the Supreme Court, by the Council of State, and by the President of the Republic. This is just to mention like the general structure of our higher courts and the periods of the justices and the way they are and the way they are elected. In the second part, I want to talk briefly about, okay, this is also important. There is a mandatory age requirement in Colombia for all the justices, which is 70 years old, 70. It used to be 65 until like a couple of years ago, it was until 2016, it was 65. But then the law changed and now it's 70 years old. That's the mandatory age retirement for every public servant in Colombia, for all the public servants, not only the justices of the court. Second part, the historical discussion on this issue. And here I refer to a fascinating work by a professor of law. He teaches at Universidad ICESI in the city of Cali. His name is Mario Cajas. And Mario wrote a fascinating this was his doctoral thesis at Universidad de los Andes. And Mario wrote a fascinating thesis about the history of the Colombian Supreme Court, a thesis that starts in 1886 with the last constitution of Colombia in the 19th century. This was the constitution that was amended in 1991. This year we are celebrating 30 years of the Colombian Constitution of 1991. So the Colombian Constitution of 1991 amended the Colombian Constitution of 1886, which is the last constitution of the 19th century. That constitution had certain amendments, but it was basically the same constitution for over 100 years. So what Mario Cajas, who is also the chair of the department at ICESI, wrote was the fascinating history, a political history of our Supreme Court. He wrote a 2-volume books. It's 2 books because it's over more than 100 years of history of our Supreme Court. So I was reviewing Mario's work before this talk. I even talked to Mario, and what it's fascinating about the work of Mario is that we have had in the history of the Supreme Court, because in the Colombian Constitution of 1886, there was no constitutional court. There was the Supreme Court, and then came the Council of State. We basically had everything. We tried everything in our constitutional history. In 1886, for instance, in the Colombian Constitution of 1886, the justices had no term. There was a life term for justices of the Supreme Court, but that was very, very short. That was only from 1886 to 1905. To 1905. So it was only for less than 20 years, the life term of justices. Subsequently, from 1905 to 1910, we had 5-year terms, but we have the possibility of re-election for justices. And in 1957, this was after Colombia's dictatorship, the only dictatorship that Colombia had in the second half of the 20th century. Again, the justices were appointed for life. They have a long, they had no term, they have life term periods. And finally, in 1979, we arrived to the current state of issues. It's 8 years with no re-election, exactly what we have in the Colombian Constitution of 1991. So the model that we have in the Colombian Constitution of 91 is something that we arrived from the late 1970s. So the question, and this was what my part of my conversation with Mario and within his work, is how is it that, and this was only for the Supreme Court, remember, how is it that we try like these different models? How to explain that sometimes we have like no term, and then 5 years, and then 5 years with re-election, and then why again no term, and basically like the way to explain this was the fights and the political controversies between the judiciary and the government. I mean, like what can explain is like every time there was like a fight between the president and Supreme Court justices, a serious fight. For instance, when the Supreme Court decided to invalidate certain laws enacted by Congress and supported by Congress, so there was a reaction of the political executive basically trying to impose limits to the court. And sometimes, but Colombian judiciary in general is a judiciary that has been very independent, that it has been very independent of the political executive, of the executive power. In general, the independence and autonomy of our courts, it's quite solid. And this in part has been granted by the fact that justices elect themselves. That's how they have granted the independence. At the same time, these also have brought discussions, and I'm sure David's going to talk about this in Ecuador as well, about how easy it is to renew the doctrines of the courts when the justices elect themselves. And let me connect this with the current situation with 1991 onwards. At the very beginning of the Colombian Constitutional Court, people will say the Colombian Constitutional Court is great because justices do not elect themselves. So they bring like new doctrines, they view new approaches to the law. There is no this colonization of the private law people of the court. We start like to give more power to justices, and constitutional law is something more serious, has a teeth, etc. However, this was not always the case. For instance, during the presidency of Álvaro Uribe was a president who reelected himself for 4 more years. He almost had the power to elect more justices of the court because he was able to stay in power for 8 years. So that created a disbalance in the court, even though our court is still very progressive. He did not co-opt the entire court. But what I try to say is that that idea that if the Colombian Senate is involved and justices do not elect themselves, that will grant like more independence of the Constitutional Court is still very fragile. And this is what we have been seeing in the last years in the process of nomination of justices before the Colombian Constitutional Court, that there has been an attempt to Colombian governments to conservatize the court, to elect justices that are not very progressive, that are not very liberal in the way they were in the 1990s and early 2000s. So the risk of the Constitutional Court being co-opted, it's always there. Right now, there is a process for the selection of a Supreme Court justice, and the list of 3 people has to be sent to Senate by the Council of State. There is a very interesting discussion because the justice that is leaving is a very liberal justice. But the Council of State is trying to set a list of names that reflect like very different ideologies, some conservative, some liberal. But if the majority of people in the Senate is conservative, they're going to vote for a conservative. So if the Council of State really want to replace this justice for another liberal justice, what it has to do is to arrange a 3 list of names of liberal people. We'd like to grant that balance in the court, because right now we have some liberals, we have some conservatives. So that's kind of the discussions that we have had recently in Colombia, particularly with the Constitutional Court. 2 final things to leave time to David. There has been some attempts to extend the period of the justices, like some bills that had been proposed to have 12 years period and not an 8 years period. I haven't understand very frankly why to add more years. I mean, like those bills are usually poorly justified. I think 8 years is fair, is fine. There have been also that the last one was in 2015, attempts to increase the experience of the justices before they arrive to the court. There used to be a case that they could arrive to the court only with 10 years of labor experience. In 2015, they changed that rule, and now they can arrive with 15 years of experience. But still, people in Colombia leave law school at a very young age. 21 or 22 years old, you leave law school. So in 15 years of experience is someone who is 37, for instance. That's pretty young to become a justice of the any Colombian court. The last attempt was to put a 20 years experience requirement, 20 years of experience. That one hasn't been approved yet. So right now the rule is 15. I do think that justices should arrive to the court later in their careers, because we have exactly the same problem here, Chital, in Colombia, that when justices leave the court, they are very young, let's say 50 years old or 51 years old, and basically they usually don't go to another position in the executive. What they usually do is that they go back to private practice, and they only have a prohibition of 1 year to litigate before the court that they used to work. But 1 year is nothing. So after 1 year, they start to bringing up cases sometimes before the justices that were their colleagues, their mates in court, their colleagues, their fellow colleagues in court. So we definitely have a problem. It's not a problem only in the judiciary. In general, it's a problem that we have in the legal profession in Colombia, and it's the movement between different sub-legal professions. So let's say someone that moves from private practice to a public position and then go back to private practice, or someone who is in the academy goes to the court and then goes to litigation. Some of those movements are more problematic than others. So I definitely think that justices should arrive to the court later in their careers to avoid these issues. And the other thing is that in Colombia, people still retire at a very young age. They get their pension at a very young age. Women at 57 and men at 62. So if you move a little bit closer, like the age to be in the court to those ages of retirement, I think that makes more, that would make more sense. I definitely have justices that arrive to the court at 40. I think is not a good idea. So I think I will leave there. I think I brought a lot of things to the discussion, and I'm happy to talk more about these issues in the Q&A. Thank you again, Sheetal, for organizing this.
Sure. No, thank you so much for talking about the Colombian experience. And I'm going to turn it over to David to talk about Ecuador, where he is a professor in charge of the human rights program at the Pontifical University, and as well a litigator before the Constitutional Court there. So David, do you need to?
Thank you.
Sure.
Yeah, I want to project. So
can you share the screen? Well, I think you should be able to.
No. Oh yeah. Sorry about that. Okay. Okay. Oh no, sorry. Just give me a second, I think. Okay, technology is it's not helping right now. Okay, I think
we can see it. I can see it.
We can see it. Yeah.
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 Oh, okay.
No.
No.
No,
okay.
no, not anymore.
I think it's because okay. Now you will see it, I think. Okay.
If you want to email it to me or start, you can do that without it too. Yeah, we see it.
Okay. Okay. I don't know why you're watching the small version of it.
Okay. No, we see the
okay.
big. We're good. Yeah.
Okay. So I'm gonna talk a little bit about two courts that we can compare. We have been in these years through a lot of changes in judiciary, and we have had a lot of instability in the Supreme Courts. So let's start talking a little bit about the period of analysis of this study is between 1979 and 2021. And this is the period of the return to democracy for Ecuador. We had a military dictatorship before 1979. So in 1979, we enact a new constitution. And in 1997, we got a coup d'etat by Congress against President Abdullah Bucaran. And after that, we got a new coup d'etat against President Rosalía Arteaga that was deposed in the same year. She was the first woman in charge of the presidency and the only one that we have had in the history of Ecuador. By 1999, we got a new constitution. We enacted the new constitution with some reforms and the judiciary courts. Then we got in 2000 a new coup d'etat by military forces against President Jamil Mawat. In 2004, in a coordinated action among President Lucio Gutierrez and the Congress, the Supreme Court was dismissed. And in 2005, we had a new coup d'etat by the Congress against President Lucio Gutierrez. And in 2008, we enacted a new constitution. And finally, in 2019, we got the Judiciary Council dismissing 8 of 21 judges of the Supreme Court. So we have been very busy in Ecuador, as you can see. In these 4 years of democracy, we haven't had a stable political system, and that reflects on the courts. So we studied 10 courts in this period of time. As you can see, we changed a lot the term periods of the court. We started with a 6-year term from 1979 to 1984. Then we reformed the constitution and we established a 4-year terms for the judges. Then we returned to 7 years term, and then we have a life tenure for judges of the Supreme Court from 1998 to 2008, and starting in 2008 until now, we got a 9 years period of time. But as you can see in these 10 courts that we studied, just the first 3 courts ended their periods. So from 1997 to 1992, actually the judges that we appoint to the Supreme Court ended their terms. Starting on 1992, we have problems of the post Supreme Courts. But we got these 2 terms starting in 1998 to almost 2004 and 2012 to the 2019, when we got 2 stable courts that we can compare. Also, so what were the causes or instability in these courts? In 1997, by reforming the Constitution of 1979, all the court was dismissed by a legal reform. In 2004, by decision of the Congress, all the court was dismissed in an unconstitutional action. This became a case against the Inter-American Court of Human Rights, the Quintana Coelho et al. Versus Ecuador case. In 2005, by decision of the Congress, all court was dismissed again. In 2008, by enacting a new constitution, all the court was dismissed. This was a legal reform. And in 2019, by a decision of the Judicial Council, 14 of 21 justices were dismissed in an unconstitutional action, and we got still litigation at national level in progress. This is some data about the diversity in Ecuador Supreme Court of the same 10 courts that we analyze. And as you can see, the first courts, there was no woman in the Supreme Court until 1997, when 2 women for 31 justices were appointed. But these 2 women disappear after the cooptation system started working. The cooptation system is the same one that Esteban described in Colombia. The judges appoint themselves the new judges. So in 1997, we got an open process of application to the Supreme Court, and then we elected the first 2 women in the Supreme Court. But one of them retired and the other one died. So they were replaced by cooptation, and the male judges appoint another male judges in this period of time. So we returned to 0 women in the Supreme Court. And starting in 2005, we have had some women in the Supreme Court. The best distribution was in 2011, 2019, when we got 8 women of 21 women in the Supreme Court, or 21 justices in the Supreme Court, and right now we got 5. The other statistics that we have here is indigenous people in the Supreme Court. We only have 1 in the whole history of the Supreme Court and of the Ecuadorian state, 1 indigenous person in 2011-2018 court. And we have had no African descendant appointed justices in the Supreme Court of Ecuador yet. So there are some issues that happen also in the Constitutional Court. We also got, not as Colombia, we only have 2 Supreme Courts. The Supreme Court that deals with with criminal, civil cases and administrative cases. And then right now it calls National Court. It's not Supreme Court, it's National Court right now. And the Constitutional Court. The same instability that shows the Supreme Court, we can reflect it in the Constitutional Court also. By 1997, the Constitutional Court was created, but in 2004, the same Congress dismissed the whole Constitutional Court in 2004. By 2005, also, there was a decision of Congress to dismiss the whole court. And then we got recess of more than a year with no Constitutional Court in Ecuador. By 2007, by decision of the Congress, all the Constitutional Tribunal at that time was dismissed. And in 2008, in the new Constitution, we changed the Constitutional Tribunal to a Constitutional Court. We dismissed the whole Constitutional Tribunal. And by 2018, by decision of the Participation Council, all the court was dismissed, and we got a new court now on the bench. We also got a case for the dismiss of the Constitutional Tribunal in the Inter-American Human Rights Court, the Camba Campus et al. Versus Ecuador case. Okay, so I think it's useful to compare these two courts that probably were the most stable courts, but that we got, but they ended unconstitutionally. They didn't end their terms. So the two courts are the Supreme Court of 1997 to 2004 and the National Court from 2011 to 2019. The one got a life tenure and the other fixed terms for 9 years. The first one, the Supreme Court from 1997 to 2004, survived to 4 presidents. So that's something significant for Ecuador. The National Court, 14 of 21 justices were dismissed when President Correa ended his last term. So the stability of this National Court depended on President Correa being on the presidency. The cooptation method helped the court to stay independent. I arrived to the same conclusion as Esteban. However, it reflects the lack of commitment of the elites to diversity. So elites tend to pick judges that are from the same law schools. They are white and male justices. There were white and male justices, and also there were conservative, as we're gonna see. In the National Court had an open call to a selection process, allowed a more diverse court to be elected. Most of the justices were aged law professors or experienced judges from past Supreme Courts or lower courts in the Supreme Court of 1997, 2004. And in the National Court, most of the justices were middle-aged practicing lawyers. This is relevant because of the incentive that the life tenure give to more experienced law professors and judges. In the professional opinion of lawyers in the country is that the court of 1997 to 2004 was more professional and independent. The presidents were respected and consistent. However, it was a very conservative court regarding especially human rights or civil rights. The professional opinion of the National Court of 2011 to 2019 was that the court was less independent, the precedents were not consistent and intense, but it tends to be more progressive. They include the constitutional rights provision in their rulings. The public opinion of the Supreme Court from 1997 to 2004 is that the court was controlled by political parties. And in the National Court of 2011 to 2019, the public opinion was that the court was controlled by the president's party. But no data on professional opinion is available yet, or consistent available right now. Some conclusions of this comparison. The first three courts completed their terms in a period of strong political parties from 1979 to the coup d'etat in 1997. Starting in 1997, political scientists have defined our political system as a crisis of the traditional political parties. So the following 5 courts did not complete their terms in the period of crisis from 1997 to the election of Rafael Correa in 2007. The most extended period of stability was from 2008 to 2019, one transitional court and one national court, and it corresponds to the period of Rafael Correa in office from 2007 to 2017. Starting in 1917, every time the political balance changed among the political parties, the Supreme Court has been changed using reforms, legal reforms, or unconstitutional actions. The last crisis in 2019 occurred when President Moreno decided to turn against the leader of his party, Rafael Correa, and make a coalition with right-wing politic forces, including the current president, Guillermo Lasso. So inferring a conclusion from the data, we should not expect a radical interference on justice's terms until President Lasso end of his term in 2021. We will see if we can prove the conclusions of the study. There are similar findings regarding the Constitutional Court of Ecuador. However, we have not yet collected enough data about the Constitutional Court. So Life Tenure Court was one of the most respected courts in the last 40 years of democracy. Its precedents were landmark cases studied at the law schools. However, the cooptation method showed the tendency of elites of reproduce themselves with a lack of commitment to diversity. The court tended to be conservative too. Also, life tenure attract higher profile candidates to the court. The last fixed terms courts have more diversity on their benches. The court was more committed in applying the Constitution, especially civil rights. However, the stability has shown more dependent on how strong is the political influence of the president of the republic. So these are preliminary conclusions of the study, and as you can see, in Ecuador, we had the opportunity to have both systems, and we have the chance also to compare. However, it's a very short period of time, 4 years, to arrive to more solid conclusions. But this is the conclusion that we can share to this discussion. Thank you.
Thank you so much, David. I think that was so fascinating that you can do a kind of internal comparative study, which allows you to keep many other factors constant, but you show the changes made when you move from a life tenure system to a term limit system. And I just wanted to highlight a couple of similarities, and then I will open it up to questions. I mean, I think we all in our look at India and Colombia and Ecuador have found that term limits do lead to some risks of when young judges, when judges who are young, what are the risks when they retire early? It could be pandering to future employers. It could be using the relationships they developed among other judges and arguing before these judges, and potentially, impacting cases in that way. Also, we talked. I mentioned maybe some of you have joined about the doctrinal instability that's created in India, with one of the reasons being the constant turnover. And finally, what was interesting is how we would go in the US from a system of term limits, from a life tenure to a term limit system. Would we dismiss the entire court the way it was done in Ecuador and recreate one? I mean, that's not the proposal. The proposal is to just sort of term people out, but that's interesting to learn from Ecuador, how a possibility of how one goes about structurally making this shift And really, finally, what I loved is so interesting is that I did a study about diversity in the Indian Supreme Court, and we found that when the judges moved from a system of where it was executive led and self appointments, they also did not concerned about diversity. They were both concerned about regional diversity and religious diversity, but not gender diversity. And here you see that also in Ecuador, when judges self-appoint each other, there is a negative consequences, or certainly not positive consequences for the nomination of female judges. Okay, so with that, I'll open up to questions from anyone. Esteban, you want to say something? Go ahead.
Yeah, no, I just want to, and thank you, David, as well, for that fascinating presentation. Maybe I wanted to say something about doctrinal instability, and what Chital calls doctrinal instability in her presentation and in her paper. And I'm thinking about the abortion discussion, discussion about abortion. And I'm thinking about this because right now the Colombian Constitutional Court is taking up a lawsuit against the criminal code in Colombia that still criminalizes the abortion, something that Congress has not, an issue that the Congress has not taken up. The court is taking it up now. And it used to have this discussion. The discussion was, there is an important decision of the Constitutional Court of 2006 regarding the crime of abortion. In that decision, the court says that abortion will not be a crime when the health of the woman is in danger, when she was raped, or when the fetus has some kind of malformation. I don't know how to say this word in English, but when there is a problem with the fetus. So you will say, okay, so that's a decision of 2006, and the Colombian Constitutional Court again takes up the issue 15 years later. Now what the lawsuit says is, what the challenge to the law, it says this should not be a crime in any circumstance. This is not the way you deal with abortion through criminalization in the criminal code. And I think that's good. That's fair. This is a contested issue, something that it's an issue in which society hasn't agreed. There is different position. There's always the view and the influence of the churches in this discussion. And I think that in contested issues like this, it is good, what Chital called some sort of doctrinal instability. But the other way around to see this doctrinal instability is, this is a contested issue, and the court participates in an open and democratic dialogue in which different actors, this time the court, is still discussing on this issue, because the place where this should be decided, which is Congress, is not doing it, is not taking it up. So if term limits for judges allow that this kind of discussion continues, I think that's good. I mean, that makes a good argument for changing justices every certain number of years. What some can be said as doctrinal instability can be seen as well as a way of a democratic dialogue taking place, this time pushed by the courts. So I just wanted to add that idea about that conversation.
Can I pipe in here? Yeah. So
Please go ahead. Yeah.
Yeah. It's really interesting presentations. Thank you very much. And it's such a topical issue, so it's very interesting to hear about these different experiences. I have two. I'm not a constitutional specialist, and so, but I do have two questions that go to So the difficulty, I guess, of studying term limits in a comparative context, because there's so much variation in that context. And so the first is the way in which the court systems are organized. And was really interesting from Cital's presentation, as well as the presentation Esteban's on the Colombian system, was, to me at least, was that I always assumed that so the considerations for a constitutional court are different from a one that has general jurisdiction. And so that's how you learn about it in Europe, where you always have a constitutional court that has, not always, but most European jurisdictions have a Kelsenian system, in the sense that there's a separate judiciary that's responsible for adjudicating constitutional cases against the legislature, for the most part, and the government in certain instances. And so you have this concentrated review system. And so the considerations for term limits there are very different from the ones in the general judiciary. And so the general judiciary is seen as this professionalized body, and it's, you know, it's totally under the control of a civil service kind of mechanism. And then the constitutional judiciary is part of a political appointment system, and it has term limits. And I think I was just looking at them as you were talking, because things I should know, but Italy has a 9-year limit, and I think Germany has a 12-year limit, maybe. So, or 15 years. But in any case, they have limits on the constitutional side, but on the ordinary judiciary side, it's a career thing, and also it's within the control of the judicial branch sort of council, which is really what Cital, I think you were describing, where you have sort of a self-governing body of judges who are responsible for appointments, and also what was, I think, David was talking about a cooptation mechanism in appointing judges. So that's a mechanism that has problems, but that's used for the ordinary judiciary. And then the constitutional judiciary has this very different logic to it. And what was interesting to me about both the Indian presentation and the Colombia presentation was that it seems like, you know, it's the politics of this are the same, regardless of the kind of case. You know, so you have fights over judicial appointments for the Supreme Court of India, which, you know, has this general jurisdiction, and it seems to affect, these fights seem to be kind of generalized. They're not so much, they're not only about the powers to strike legislation. And then in Colombia, you have the same system that basically, except for those 3 judges on the Constitutional Tribunal, you have the same system of essentially judicial self-appointment for, you know, through this kind of self-disciplining body of the judiciary, but I would call it maybe a corporate body for the judiciary across all 3. And so that's something that I find very interesting, that, you know, because the common wisdom when you're teaching about, you know, European jurisdictions that come to judicial review later than America is that that's always seen as special compared to the professionalized, you know, ordinary civil criminal litigation. So that's one just point that I wanted to maybe see if you have thoughts on. And the other one is that listening to your presentations, it seems like in trying to understand the importance of term limits, what you need to really understand is the ecosystem in which lawyers are working. Because when you talk about, you know, the main danger of judges deciding cases looking to the next job, the issue really is like, what is the next job? You know, like how lucrative can that next job be, and where will that next job be? So, like, you know, so Cital is talking about how, you know, government jobs are very lucrative because there's this special system that controls, you know, property, and, you know, you can get very good compensation. And so, and then in the Ecuador case, it seems like there's, and also in the Colombian case, there seems like there's this ambition of kind of going and afterwards litigating for a private firm, and or maybe going back to academia, and that is remunerative enough. Whereas in the United States, it would be totally different. I mean, what the concern there is that people go off and they work for Facebook, right? Because, you know, if they're not really concerned about their reputations, they're going to go off to multinationals and make the multi-million dollars that they weren't able to make during those 18 years in the judiciary. So it seems like it's hard to generalize, actually. It's like each country has this very different set of incentives that goes to like really the whole structure of the economy. So I was also wondering if you have thoughts about that too.
So yeah, thank you for those observations. And I think they're perfect, great comments. The first point about the distinction between general jurisdiction court and constitutional court, obviously for the Indian case study, as you noted, I mean, the Indian court was founded in 1950, where, the earlier, like the Colombian courts and Ecuador courts have followed the more recent model of splitting up courts, whereas the Indian court as still continues to be both a general jurisdiction and a constitutional court. And then the debate then is just merged together, right? And maybe if it were separated, they would feel more comfortable with having life tenure or greater tenure for the Indian the court that just deals with non-constitutional matters. So yeah, I don't have any particular great insights into that, other than to say that that's that's super interesting to learn about in the Europe example of life tenure meaning a lot less. But maybe David and Esteban probably have more to add on that point, because they have the distinct system. And your point about the ecosystem of what lawyers do and what retiring judges do is different in both countries, or in every country that we were talking about, is a good one. I think you're right. In the United States, they might go into private appellate practice. They probably would go in-house and use the contacts, either Facebook, general counsel, whatever policy, and use those contacts to enhance their profile before the court. But I still do think that even still, there's still a chance for, maybe there's a chance for problematic consequences, and maybe it's not exactly pandering. In the Indian system, you have a more direct example where judges are going to go, the government is the biggest litigator, judges are going to go want to work for the government. Whereas here, you'd probably have in the US Supreme Court, they take so few cases to begin with, and probably, Facebook might have a case, might not have a case, right? There'll be a diversity of employers in the US system that a judge can go to as compared to the Indian system, which creates that distinction, then makes you wonder, well, the same pandering incentives then maybe aren't here in the US. But one could still argue that they would use the knowledge, the contacts, things that they've developed. There's a risk that they then take that out into the system. So maybe it's a different risk than what a different risk of later influencing decisions rather than pandering beforehand. They maybe have power after. So maybe it's what you say makes me want to add that kind of distinction into the thinking and the paper, for sure. So David, do you want to respond? And Esteban, go ahead, Esteban.
No, with regard to your second question, I totally agree. I mean, like the context and what happens is like, and there are so many justices in different courts that it's difficult like to track those trajectories after court. Something that I have seen particularly in the Colombian Constitutional Court case in the last years, there is also an attempt of Colombian justices, for instance, to go to some of the institutions of the Inter-American system of human rights. And I guess that in Ecuador is the same, David. So like the experience of the Constitutional Court to then be part of the Inter-American Commission of Human Rights or the Inter-American Court of Human Rights. And I think that it's not necessarily bad, But as you were saying, Francesca, it's interesting, like, to track their history in the court, to analyze if at some point of a certain way, like, their decisions were trying to follow that path, like, because as I said, even recently we have a Supreme Court justice, a Constitutional Court justice who retired after living in office for 3 years. His name is Carlos Bernal, a pretty conservative justice. And Bernal is now wants to be a part of the Inter-American Commission of Human Rights. Someone who didn't even finish his term in the Constitutional Court. With regard to your first question, honestly, I don't know. I think that at least in the Colombian case, they are all very political. All these courts, they do politics in different ways. They do politics to elect their members, and David is quite. I mean, like, that's quite. These are still pretty conservative institutions, not very diverse. The regional thing might be an important thing, but maybe the only way in which diversity can be seen. There is a very good researcher. She's now in McGill in Montreal. Her name is Maria Ceballos, and she's writing her doctoral thesis on the issue of gender diversity in Colombian courts. And still, I mean, like, the numbers of, because this what she says, this is a country of juezas and magistrados, the female judges and male justices. What I was saying is they're all very political, and still the Council of State has a very important function with regard to all the administrative decrees that the government issues. So there is a connection between the executive power and the Council of State because of the functions that they themselves develop. And in the Constitutional Court, of course, because I mean, like, the nature of the work is to control a political constitution. So of course they issue I mean, they take up issues that are themselves political. But it's interesting, and thank you so much for those comments, Francesca. Question.
Well, so those are difficult questions. I think is very interesting, and especially to compare. First, Ecuador is a very unstable, got a very unstable political system, as we saw. So the case is very particular, I think, but at the same time, it gives you some insights about these difference about terms, for example. So if we go to the second question first about the future jobs that these judges can get, we can see the ages of the judges depends on the terms, I think. For example, when we talk about the life tenure judges, more respected and experienced lawyers or law professors and judges from lower courts wanted to apply, wanted to present their candidacy to the Supreme Court. So that is really interesting. I think it's because they see the end of his career or her career in the judiciary, in the highest court. But when we put limit terms, even if right now is a long term, 9 years, not 18 years, but 9 years. We got the tendency of lower profiles applying to those jobs or those positions to the two Supreme Courts that we have, the National Court and the Constitutional Court. An example of this is that we got to change 3 constitutional judges on February, and we got a list of nine lawyers to fill those 3 positions, and the age was among 35 years, so it is very young people. The oldest candidates got 41 years, so they will be very young at the end of their periods. With the 9-year periods, they're gonna have 50 years at the end of, in the best case scenario. So they got to think, where are they gonna work after that? So with these fixed time terms, we got this tendency. When we have talked with some law professors, for example, that are specialists in the area, they well respected. When we talk with them, they said, okay, with 50 years, I can find another job, but with 60 or 65 years, it's gonna be harder. So they see the terms as a limit of their career possibilities. After 9 years, they see like they're gonna lose their clients or their private practice. They're gonna be elder professors. They're gonna take distance from the academia also in those 9 years. So so that's why they don't apply to those positions, and we are resenting that in the quality of the production of both courts. That's one thing. About the difference among the National Court and the Constitutional Court, actually that is very interesting, because the court that got more power, the Constitutional Court, the one that can police the decisions of the legislative and the executive, and the one that deal with the more controversy issues like abortion and gay marriage, etc., is the one that got the tendency to get younger judges and even less experienced applicants to those positions. So for the first lecture that we have, the first reading that we have about that, is that if they are younger, probably it's going to be more controllable from the political parties. So that's one theory. So they got to be very grateful to the ones that put their names on the as candidates, because the Constitutional Court doesn't have an open process to apply to the Constitutional Court. There are 9 candidates. 3 of them are from different powers in the state. So they got to be grateful. They're gonna be young, so they got to look for jobs when they they are in the 50s. So I think that's the incentive for the politicians to pick younger and younger judges. So there is a difference, and the National Court that deals with criminal, civil, and administrative cases, there tend to be a little bit more experienced judges, but they are not. They are on their 50s, especially, so they are not aged either. So that's it. I think that matters a lot. Yeah. Thank you.
So if anyone has other questions, and the one thing I would, and feel free to raise your hand or just interject. The one thing that I draw from this to commonality, learning from you and Esteban David, is that we assume, right, scholars, Calabresi, Lindgren, the Biden Commission assumes that, well, in the term limit system, that they won't be appointed, judges won't be appointed at young ages. But I think your in Colombia and Ecuador case studies sort of prove that wrong. They suggest that even under term limits, there's incentives to appoint them at young ages. And I think that that's maybe what we should be thinking about is, this is where the comparative knowledge, I think, gives the salience, or gives the bang, is the payoff here for the United States, which is to think more about the fact that the judges will be young and they'll have a working life after them. And how do we account for that? And what should we do for that? And as I mentioned, none of the proposals, there's a bill in the US House of Representatives, it doesn't prevent private practice or working at Facebook, or working at Google and taking, that knowledge. So Google has a big antitrust case with the Supreme Court, and a former judge can say, well, I know how Judge so-and-so is going to react. That was the conversation we had in our private conference, but nobody else knows that, right? And so that is a different consequence than in India, but it's a consequence here that we should consider more if we're serious about term limits, which may, even though the commission thinks they are serious about it, and that might be the only proposal that comes out of the commission, it still may not happen.
Can I ask a question, interject here, just on the merits, since you know so much about it? How is there any prospect of ever getting this 18-year term limit? I always am so skeptical. I mean, because of the difficulty of amending the Constitution. What's the strategy on that? That's why I always thought that packing the court was really the only possibility. But
yes. So that's the barrier. So increasing the size of the US Supreme Court can be done by statutory action, and that's resolved. They've done it over time. So that's actually pretty possible. But I think this particular commission, someone has, like Maya Sen, a Harvard political scientist, and like half of them are from Harvard anyway. And so she comments saying, like, they just are too embedded in the system, and they gain so much from the system that they just don't feel comfortable changing it, right? They think, wow, legitimacy would be sacrificed if we increase the size of the court. And so they are agreeing. The conservatives and the liberals are on the same page here of we don't want to actually propose a solution that could actually be implemented. But the solution they're suggesting, the term limit solution, as you say, there isn't clarity for it. Some scholars have argued it can be done by statutory amendment. But then if they do that, the Supreme Court can say, well, that's unconstitutional when it comes to the court, right? Which is what the Indian Supreme Court did when Parliament tried to move from this self-appointment system to a judicial commission. They said, oh, this bill is unconstitutional because it violates it's called basic structure of the Constitution because it compromises our judicial independence. So the safest bet is to get a constitutional amendment, and we all know how hard that is to do. Yeah, I agree. It may not actually happen, even if the commission winds up proposing it. It will require a lot of work and a lot of change. But the 18-year limit seemed to get consensus across the aisle because nobody really knows what's going to happen. Everyone knows right now if Biden gets 4 more judges, what he's going to do, but no one really knows what'll happen if we move to the staggered term limit system. Awesome. All right. Well, thank you, Francesca, for joining, and for Lynette and Luis, everyone here. I really appreciate it. David, it's been, Esteban, it's been really interesting. And thank you, Francesca, for suggesting that I increase the size of this panel and have this conversation. I remember you said that to me. So
you can see I'm self-interested in having you do it because I can learn about the rest of the world. I'm too focused on Europe.
Thank you all.
Thank you for that.
It was lovely to see you and share this afternoon with you guys.
Thank you. All right.
Thank you.
And thanks for the organization work, Francesca, for this whole conference.
Thank you.
Bye.
Bye-bye.